So good afternoon. We're here at Arlington National Cemetery. And a few people have asked questions about how Chevron will affect CPS. They've also asked how what I'm doing is going to impact them with regard to any sort of CPS case. And I've taken a little time to get ready for this, to be able to discuss this. But let's talk about it now. So one thing that we have to understand is that what I'm trying to do, yes, what I'm bringing forward is a criminal matter, right? The absence of the grand jury is absolutely a criminal matter. It's not a civil matter that affects CPS. But the larger argument has to do with something much, much bigger than simply an indictment by a grand jury. Just as I said in the video just the other day, what we're doing is we're bringing together a very, very major issue. 700,000 people across America today that are illegally and unconstitutionally imprisoned because the states failed to follow the basic procedures and processes codified in the Constitution of the United States for the adjudication of crimes. But we're doing that so we can bring up a much, much bigger issue, and that is that states don't have authority to be able to oversee and be a judge in a case in which they themselves are a party. So when you deal with CPS, you have to understand that CPS is an agent of the state, right? What they're doing is they're enforcing the laws of the state, right? So they're part of the enforcement branch. So they're actually operating under the authority of the prosecuting attorney, who is the highest law enforcement officer within the county. So they are absolutely a government agency. And anytime the government becomes a party in any cause, the government must recuse itself, the state must recuse itself from being the judge in the cause, because no man can be judge of both party and judge in the same cause. So if a state becomes a party in the cause through any one of its agents, and that includes CPS, it includes law enforcement, it includes the judge himself, if the state becomes a party in the cause, then the state itself cannot be a judge in the cause. And that's codified in Article 3 of the United States Constitution, where it says, in all cases in which a state shall be party, the Supreme Court shall have original jurisdiction. So if a state becomes a party in the cause by bringing an accusation of a violation of one of its laws through one of its agents, being CPS, being a prosecutor, whoever that might be, then that state must recuse itself. The judge must recuse himself from being a judge in the cause because he has a conflict of interest. He works for the plaintiff. And so original jurisdiction, meaning that the court that must act first before any other court in the country can act, must be the United States Supreme Court. So you don't go to the lowest court in the country to deal with this issue. You must go to the highest court in the country, because that's what the Constitution of the United States demands. It's what it says must occur. So another thing that we need to understand is the difference between criminal and civil burden of proof. The state must always prove its case. The system is already arrayed against the individual. Therefore, the state cannot have additional advantage in the proceedings. And that's why in a criminal matter, the individual is innocent until proven guilty, right? That is the way that it's supposed to work. He's innocent until proven guilty. Therefore, the burden of proof lies upon the prosecuting attorney. They must prove that someone is guilty based beyond a reasonable doubt. That's the burden of proof that exists in a criminal matter. Now, going back to information, when we deal with information, what happens is that an accusation comes forward through one of the state's agents, being a law enforcement officer. Let's say that someone called up the police and said that something happened to them. The police come over, they collect that information, they reduce it into writing in the form of an affidavit, and then they submit it to the prosecutor and the judge to say, hey, I'd like you to hold this person to this offense that we claim happened based upon our oath or affirmation. But unfortunately, that officer has no idea whether or not that information is factual and correct, because he wasn't a witness to it. He simply took someone else's information and is now presenting it based upon his own oath, which actually makes the arrest itself unconstitutional, a violation of the Fourth Amendment, because the Fourth Amendment says that no warrant shall be issued but upon probable cause supported by oath or affirmation. When the officer himself, who was not a witness to the cause, brings the accusation together based upon his oath, that's in violation of the Fourth Amendment, because he was not a witness to it. His oath doesn't matter. What matters is the individual who's making the accusation, whether or not they present the information by their oath, right? So, but what happens now is that the burden of proof shifts from the prosecutor onto the defendant, because they're now charging him by information, by just simply an allegation that has not been verified, validated, because the defendant or the accused has never had the opportunity to be able to confront that accusation against him. That's the purpose of the grand jury proceeding. So The burden of proof lies onto the state to prove their case. The state must always prove their case. Everybody knows that. You all understand what I'm saying. Burden of proof lies upon the prosecutor to prove that you are guilty beyond a reasonable doubt. But when they bring the accusation through information, right, that's unfounded, right, that has never been verified or validated because the accused never had the opportunity to be able to confront that accusation against him, then the burden of proof shifts. It's no longer the prosecutor, the state that has to prove their case. It's now you that has to go out and collect evidence to prove that you're innocent. And that is a shift in the burden of proof. It is unconstitutional, but what happens is now you are presumed to be guilty based upon the mere fact of being charged with a crime or being accused of a crime by an agent of the state. Now let's shift gears to the CPS matter. So if you have the right to be innocent until proven guilty and the state has to prove their case, then you must have an inverse right or the exact equal right within the CPS matter of the presumption of being fit to be a parent. Right? The state must prove that you're unfit to be a parent. So when the state comes in with the presumption of being unfit, that would be the same as the presumption of guilt, right? So, we can see that one part of law functions in a certain way, and we can presume that another part of law is going to function in the exact same manner. So if there's a breakdown of due process that exists within the criminal side, then we will see the same breakdown of due process that exists within the civil side as well, particularly within family matters. So you are not presumed to be fit to be a parent because the state is bringing an accusation against you that you are unfit. And as a result, you are being treated as though you're an unfit parent, right? Your liberties and rights are being deprived of you because of the accusation made by an agent of the state. It's the same issue. It's the same matter. So now we have the exact same scenario where you are not innocent until proven guilty, but instead you are now unfit until proven that you are fit. And you have to go out and collect evidence to prove that you are fit to be a parent and that the state has not acted outside of their due process. And so according to Blackstone, we know that the breakdown that occurs, the shift in due process that existed within the criminal matter, that exact same breakdown of due process, it now exists within the family court as well. And so according to Blackstone, this breakdown of due process occurs when the system focuses on speed and efficiency as opposed to established procedures and processes. If you have the right to be innocent until proven guilty, and the state must find you guilty beyond a reasonable doubt because the burden of proof lies upon the state, then the exact same thing must exist within the family court as well. You must be presumed to be a fit parent until the state has proven that you are unfit. You cannot have your rights deprived. You cannot have your child taken until you are proven to be unfit through due process. Because that's the burden of proof that exists. The system is already arrayed against the individual. Therefore, the state cannot have additional leverage and additional strength, because that would be a breakdown of due process. It would be a violation of international human rights standards. We can't have that continue to occur. So when we talk about Chevron, what was going on with Chevron was that the executive branch, right? And remember, every prosecutor, the executive branch is in charge of enforcing the laws. So when you come to an enforcement element such as CPS, right? CPS is there to enforce laws. They are part of the executive branch. It doesn't matter what anyone says, they work for the executive branch. They work for the governor of the state because they are coming forward to enforce state laws. Now, because they're part of the executive branch, then that means that the Chevron matter is very, very simple. That with the Chevron matter, that they are using their ambiguity to be able to alter, amend, and destroy the law. The executive branch has no authority to be able to alter the law. That must be done by an authentic act of the people in accordance with the special amending procedure of Article 5. Any other way would be unconstitutional. And so as a result, the whole Chevron matter was it was permitting CPS to be able to create laws in violation of the United States Constitution and your right to be able to have an unobstructed access in relationship with your child without governmental interference. And as a result of this occurrence, we now have a situation where Chevron is directly impacting the ability for the state to be able to take your child and take it without due process because the burden of proof is now shifted. You were presumed to be unfit based upon an accusation created by an officer of the executive branch. They came forward and through the absence of due process has now deprived you of a right that's guaranteed by the Constitution of the United States, the First Amendment, a God-given right because God made you a mother, God made you a father. Only God has the authority to take it away. The state has no authority to do so. So I hope that helps a little bit. I hope that you guys can now understand, how Chevron is going to impact this. But the most important thing that I want you guys to take away from this is the fact that you have the right to be innocent until proven guilty. The burden of proof resides upon the state to be able to prove your guilt. And as a result, you have the exact same right within family court to be presumed to be a fit parent until the state has proven that you are unfit. And if they do not act in that manner, if they act where they are depriving you of a right, presuming that you are unfit, that is the same breakdown of due process that exists when there is an absence of the presumption of innocence. It is guilty until proven innocent, and it's occurring across the board, whether it's a criminal matter, whether it's a CPS matter, whether it's a guardianship matter, they're all the same. So the work that I'm doing is directly in relationship to that. We are bringing forward the absence of the grand jury to show the guilt until proven innocence through the failure of the state to prove their case, and the shift in the burden of proof, where we can also show that direct function and that breakdown of the structure of the system that occurs within the CPS system as well. I hope you guys have a great day. I hope this explains and clears up some of this stuff. Please continue to follow me. Please share the video. We need to get the algorithms up quite a little bit. We need to spread this a lot faster. Right now, today, we have a great deal of leverage with the election and the campaign cycle that's occurring to be able to get these people to actually take action. Because the truth is that if my information gets out there in the public domain, if I'm able to, in the next couple of weeks, make this hit the national news front, then they are going to have to take action, or none of them will get reelected. So we have a great deal of power right now to be able to force them to actually take action, do what they're constitutionally required to do. So again, follow me. Please share the videos as much as possible. Please get out there. This information is widely available. I want you guys to share it. This is going to help all of you in your individual cases. Please like, subscribe, and thank you so much. I appreciate everything that you guys do. I appreciate the support that you guys give to me. And together, we shall be free. God bless. So one important thing to remember with regard to Chevron is we got to look at history, right? Plessy versus Ferguson was the case from the United States Supreme Court where they allowed for the segregation in the South. It was a ruling that was put into place in 1884 by Chief Justice Waite. It was overruled in 1958 by the Brown versus Board of Education case, right? And everybody at the time thought Brown versus Board of Education, it will never get overruled, or Plessy versus Ferguson will never get overruled. It'll never happen because they become so accustomed to the permitting of the segregation issue that nobody believed that it would ever happen. And in fact, we know that the justices, many of them, they said in their memoirs that they didn't actually decide until that morning that they were walking in to hear the oral arguments. And they looked up as they walked in and saw the writing on the top of the United States Supreme Court that said equal justice under law. And they said, we have to do this. We have to make this happen. Well, the issue is that in 1958, when Plessy versus Ferguson was overruled, right, what happened was that the South, they refused to actually make it happen. And many of the judges in the South were refusing to desegregate. They were refusing to obey the edict of the United States Supreme Court and willfully warring against the Supreme Court of the United States and the decision that they had made. And so it took many, many years before Brown versus Board of Education actually was able to be laid out and followed amongst particularly the states in the South that didn't want to desegregate. And so a number of things happened, legislation in particular. The Civil Rights Acts of 1964 and 1968, those were because the South was refusing to desegregate. They were refusing to follow the edict of the United States Supreme Court. So, it took a long time before we actually saw the results of that particular ruling back then. And it's going to be the same way now, because Chevron is what caused mass incarceration. It permitted these prosecutors to be able to do whatever the hell they wanted to do in whatever manner they saw fit, because they said it was simply ambiguous. And as a result, they removed the grand jury proceeding so that they could arbitrarily arrest anybody that they want, in any manner they want, for any reason they want, and could send anybody to prison for any arbitrary capricious act that they deem entitles it or results in it. So it took a long time before Brown versus Board of Education, that ruling, actually, we saw it starting to play out. It's going to be the same thing for Chevron. These prosecutors, the executive branch, is going to be standing in defiance of the ruling and the edict of the Supreme Court. They're going to continue to try to operate in the manner that they currently are, because they don't want to have such massive impact to their operations. They don't want to have to change the way that they do business, because their business is booming. So you know, when you say that nothing is happening yet, Chevron ruling wasn't put in place, you know, it's not working. You guys got to understand that there is a process that happens. There's fallout that's occurring. We're going to see clashes between the judicial branch and the executive branch as a result of this, but that doesn't mean that it's not going to happen, okay? The ruling is in place. It was a fair and correct ruling. It's absolutely right. But now we're going to see a lot of different things that's going to be happening in order to require that edict to actually put into place. And that's why I say that right now, you know, moving forward to Supreme Court, we have the ability to say to them that if they do not take action, right, and do what they're lawfully obligated to do, if they don't assert their supremacy now, then their whole institution is without honor. Their whole institution is over. The power that they believe that they have doesn't exist because they are not what they say that they are. They don't have the power to do what they say that they can do. So if they can't get the judges out at the state level to actually obey the law, the Constitution, and follow their edict, the rulings that they put into place, then they are not the Supreme Court. Because the Supreme Court then would be whatever court out the state says that they can do whatever they want to do. So it is working. It is happening. You're not going to see immediate results because it does have to flow down, but that's why we have to fight crime from the top down, right? We're not going to get the results that we want from the state courts and state judges because the state judges are simply doing whatever their leadership permits them to do. And if the governors say, well, this is the way we're going to do it because this is a state issue, and the Supreme Court says, oh no, it's not a state issue, it's a constitutional issue, then we have to let the bureaucracy work its way through, because that's the easiest and most peaceful way of making it happen. We talk about having a democracy, we talk about having a republic. This is how those work. Government has to work in that way. We start at the top and then it flows down, but it takes a little while to get it to flow down. So, you know, Chevron is the correct ruling. It was put into place. You're not going to see the results that you want because these judges haven't been bound and accountable to following it quite yet. We're going to make sure that happens. And then another thing is that the Supreme Court said that this ruling is not going to go back, right? It's not going to affect cases from the past. That's not true, because it was a criminal act that was committed by a judge when they deprived you of certain liberties and certain rights. And anytime that you have a constitutional violation that occurs in the pursuance of an outcome, that outcome is unconstitutional, it's void, and anything that's void, any judgment that's void or action that's void is always and forever void. It can never become valid because it will always remain unconstitutional no matter what. So don't worry about what they say about how it's not going to back up, because they're full of it. They don't know what they're talking about. A crime was committed in the pursuance of, a constitutional right was breached in the pursuance of, and as a result, you can always and forever challenge those judgments that are in place. It doesn't matter what the Supreme Court says. The moment that a criminal act was committed in the pursuance of an outcome, that outcome is unconstitutional, and an unconstitutional outcome can always and forever be challenged. It never has a statutory limitation because it was always unconstitutional. It can never become constitutional. So just hang on and just understand that we're working on this diligently, and there are a few more steps that we need done. Right now, the big focus is that now that we've determined that the executive branch has no authority to be able to create law, alter, amend, or destroy law, because that would be a separation of powers, now we need the judicial branch to come to the same terms. The judicial branch has no authority to be able to create the law. They have no authority to be able to alter, amend, or destroy the Constitution of the United States, because that must be done by an authentic act of the people. That is the next step. We've got the executive branch under control. We're going to deal with that. Now we got to deal with the judicial branch. That's what the service on the Supreme Courts that I did, those 32 states that I went and I served the Supreme Courts, that was what that was doing. We were moving into the next phase, which is now judicial branch. You need to accept accountability for the crimes that you committed when you decided that you were going to act outside of the Constitution and declare rulings that modified, changed, or amended the Constitution of the United States without lawful authority, because all constitutional changes must be done by the people and not by the judicial branch. So thank you guys so much. God bless. Hope you have a great day.
I paid all my payments, I'm all out of patience, so save all your statements. You say from your basement, I stand on the pavement and fight for my people against you dictators. what's right, even if I stand alone. I'd rather be losing this battle than winning while fighting for something that I know is wrong, known all along.